to 5 page long document. Now, it's very important for a layman or even for lawyers to understand what basically they are entering into. So I'll begin with giving the brief background regarding what a contract is. Most of people who have legal background, they would understand what a contract is, but for a layman who doesn't understand the legality of it, we need to differentiate between an agreement. What is a contract? Agreement could be any agreement between two parties to do or not to do something. But if it's legally enforceable, that's a contract. That's really the typical technical distinguishment or the difference between the two. So basically, an agreement is that is enforceable by law, which is between two or more parties. Meeting of mind is one of the requirement. Commitment by each to do or abstain from doing anything. Uh, that's an agreement does not need to be in writing, but having it in writing is a really good idea, mainly because it creates a concrete record of what was agreed. Also, in the future, it is much easier to enforce. Now, as we've discussed the difference between a contract and agreement, recently, especially for startup culture, you would come across a number of discussions regarding, oh, we have entered into an MOU, or we have entered into a letter of intent, or we have signed a term sheet. Now, what is the difference? A lot of the times I interact with clients or even friends, they think, oh, MOU is not binding. We just entered into an MOU, or it's just a letter of intent. It's not binding on us. But that's not really true. The nomenclature is irrelevant when the courts are looking at the document. The nomenclature, although gives you an idea about what the document is all about, but that's irrelevant because content is the key. What you write inside an agreement, how you draft it, what the intention of the parties is reflected through the document, that is more important than a nomenclature. You could have, if you have entered into binding obligations, but you title it as MOU, that doesn't really change the fact that it's a binding document. That's an agreement, that's a contract. Typically, you would want an MOU to be non-enforceable or a letter of intent to be non-enforceable. It's basically a discussion regarding entering into an agreement. But depending upon the language, it may or may not be binding. So this is something that we all need to be very careful about when we are entering those discussions. So typically how we understand is letter of intent is the least formal document followed by MOU, and then term sheet is a little more formal, but still considered as not enforceable unless the language is give the impression otherwise. And the agreement contract would be the more formal document, mostly known as the transaction document also in context of investment in agreement in startups or any entity or organization. So I'll go through what is the anatomy of a contract, what a typical agreement or a contract looks like when you draft it or when you read it so that you have a better understanding of it. Typically, an agreement is basically would contain an introductory paragraph where you basically define who the parties are. The agreement is better entered into between these parties X, Y, Z. When did the agreement happen? The date on which you are entering into it, and when will it go into effect. So these are the typical discussions that go into the introductory paragraph. It's followed by the background of the agreement, what we call recitals clause. Now, recitals are basically the preamble of an agreement that gives you an executive summary of or background of what is an agreement all about. It tells the parties basically, without looking at the agreement, they need to know what kind of agreement or commitment is taking place in the agreement and what is the background behind it. Typically, for a non-lawyer, you would look at a whereas clause, an agreement where you have a whereas clause. For example, whereas party A is engaged in the business of XYZ. That's your recital clause or a whereas clause. Anyone unfamiliar with the agreement basically gets an idea why this agreement is entered into and what is the intention of it. It does not give out other details typically, but it gives you the background of that. And it's followed by the key clauses, right? Key clauses would be your money clauses or the commercial provision as we discussed. So, for example, if it's supply agreement, the money clause or the commercial clauses would be where party A wants to supply certain things to party B. Excuse me. So, similarly, in a situation where it's an investment document, which would be, for example, a shareholders agreement or share subscription and shareholders agreement, the money clauses would be that the investor is bringing in this much money, and the startup company or the investee company will issue these many shares or these instruments in exchange for that money. Basic commercial discussion, the crux of a document goes into that, or basically the main reason why you're entering into this agreement. After that, you have other supplementary clauses which are still very important clauses. For example, obligation of party. That's one of the key clauses of an agreement. Now, that defines what are the obligations of parties to that agreement. For example, there are three parties to an agreement: the startup and the founders, as well as the investors. So, the obligation of the parties are defined. What the founders are supposed to be doing during this agreement. What are the obligations of the startup as a company? What are the obligations of the investor? That would be followed by the procedural provisions. Procedural provisions basically define how the money provision as well as the obligation of the parties, those provisions are to be implemented. What kind of procedure needs to be followed? For example, when we're talking about the money provision, A is supposed to invest that X amount of money in the startup. Or how this will take place, how the closing will take place, or what kind of meetings need to be, for example, board meeting needs to be held, or the shareholders meeting need to be conducted. The procedure that leads to or helps cement those provisions, or for the realization of the money and other obligation provisions of the agreement, is what we call procedural provisions. Now, another important term would be the term and termination clauses. These are very heavily negotiated clauses in any agreement. For an investment agreement, a term is generally not clearly defined because the agreement does not end after, like, for example, 2 years or 3 years. As against your employment agreement, where the term would be generally be very clearly defined, how long is your term of employment. In an investment agreement, the termination clause is there, but it's also termination clause is generally based on certain events. So if certain events take place, the termination of the agreement, shareholders agreement, or any investment agreement can take place. One would be, for typically example, would be if the due diligence is not satisfactory. So before the closing, the agreement can be terminated. Second would be after the closing has happened, can it still terminate it? To some extent, it can still be terminated in the sense the subscription part of it will not be terminated, but the shareholders agreement that define the rights and obligations of the shareholders, that can be terminated. For example, if one of the shareholders becomes bankrupt, or a shareholders being an individual dies, or a shareholder exits the company, sells their assets, or sells their shareholding in the company. So the number of ways you can define the termination or prepare the termination clause. Another key clause would be warranties and representation. Now, this is probably one of the most heavily negotiated part of an agreement. Reason being, warranties and especially in the case of startups, investments received by the startups are generally subject to a number of warranties and representation. Now, thinking from an investor's point of view, where the investor wants to put money into a company, they would want the founders as well as the startup to give certain kind of representations and warranties. For example, they want you to warrant that the company is in good financial health, or that there are no off the books liabilities of the company, or that the company is not engaged in some kind of litigation that has not been informed to the investor, or there are no other deal breakers, so to say. There are no other concerns outside of what has been told specifically to the founder during the due diligence or otherwise before the signing of the documents. So warranties and representations are from when you're seeking warranties and representations from the investor, they're very few, because the investor only has to represent or warrant that this is they are a legal entity, or they have all the rights, or they have followed all their bylaws provisions of their bylaws to enter into this agreement. They are generally not subject to too many warranties and representations, whereas the founders or the company receiving the investment, they would be subject to a number of warranties and representations. Other important terms would be indemnity. That's a very important clause for any agreement, any commercial agreement, and this is no difference in the case of there's no difference in the case of investment agreements either. In a typical shareholders agreement, indemnity, or share subscription agreement also, typical indemnity would be the discussion would be whether the main discussion on negotiations would be who gets to indemnify who and to what extent. Is there any limitation on that indemnity or liability, indemnity liability on a party or not? So pay a lot more careful, spend a lot more time around indemnity clause and what are the limitations of it to understand who's responsible for what and to what extent. Dispute resolution has emerged as one of the leading clauses these days, especially in context of when the dispute resolution is provided in terms of typically an agreement would provide that in case of any dispute between the parties would, for example, for 30 days they'll try to mutually discuss that dispute and try to resolve it. But we all know that generally that doesn't happen, and if that doesn't happen, the dispute goes to arbitration. If your investor is an overseas investor, they generally prefer Singapore or even London as a seat of arbitration. That's also another area where a lot of negotiations happen, because they would want to minimize the role of Indian courts in any dispute resolution. Although at times that's a good idea, but one needs to be careful that sometimes that dispute resolution can be too expensive. An arbitration in Singapore may not be, or the investment amount that you're receiving may not be worth risking an arbitration in Singapore, because that could be too expensive. So depending upon the size of the investment and the transaction,
Um,
dispute resolution or the seat of arbitration needs to be determined. If it is
Pankaj,
small,
sorry to interrupt. I'm not sure if you are sharing the presentation here.
the it's not enabled for me to share the content. If you could,
Okay, just give me a second.
there's some technical issues. I'm sorry, everybody. There's some technical issue. I was supposed to really share the presentation like alongside having the discussion. However, seems to be some technical difficulty that we are facing. But definitely, we will be sending you across the PPT as well as the recording of this for your future reference as well. In the meanwhile, whenever the issue, okay, it seems it's working now. Thank you very much. Well, uh, now is it? Are you able to see Vaibhaw? If you could confirm.
Pankaj, no, it's Abhinav.
It's
Hi, Abhinav. How are you?
Yeah, fine, fine.
Okay, wait. Let me.
Yeah, yeah. Desktops is being shown.
Okay. Sorry for me being technically challenged. It should be working right now, I hope.
Yes.
Okay, thank you.
Yeah.
Thank you very much. So yeah, we were discussing the dispute resolution is a clause you want to be very careful with it. One would be mutual discussion. Second part would be if that doesn't work out, arbitration at an appropriate forum or the place. You need to discuss if it's a big ticket transaction, arbitration clause for Singapore as a seat of arbitration. Um, and location of arbitration could be justified, but if it's a small ticket uh, transaction, it may not be advisable to have arbitration clause where the arbitration is taking place overseas. The local arbitration would be a good idea. And third, in the dispute resolution clause, generally you want to subject the agreement outside of if any other disputes, for example, whether the arbitration can be involved or not. There could be dispute on that as well. Generally, again, that would be resolved by the arbitration, but at the same time, the courts of your local city should have the exclusive uh, exclusive jurisdiction over that, and the law of whether law of a particular country is to be applied or not. It's followed by other miscellaneous terms and clauses, which a number of those are boilerplate that do not require much of discussion at the point. We don't need to go in the interest of the time, but they are equally important at the same time. So the careful analysis of that is also desirable. Again, of course, the document is obviously the execution pages of the both the parties or all the parties to an agreement would execute the agreement by signing it is an important part of it. Okay, how do I move? Okay, some tips to discuss basically if outside of the discussion we already had. Recitals, as we discussed, is a very important clause because recitals are usually not subject to any limitations in terms of when the dispute occurs. That gives you a background of that. It's more like how the Constitution's preamble cannot really be changed, and that really sets the tone for rest of the Constitution, even though it's not the main part of it. Similarly, recitals basically give you the background. So be very careful to make sure that the parties are on the same page with respect to giving the background of the agreement. Warranties and representation, we discussed that it's more important from the point of view of the startup or the investee company and the founders. Investors want you to agree to practically every warranty that they can think of, but at the same time it's better to be able to draw some balance between the desires of the investors as well as your obligation. Deadlock is another clause that we could that could lead to a dispute, right? Deadlock, for example, an agreement would provide the rights and liabilities of the party or the obligations of the parties. Now when the deadlock could occur based on whether or not the parties can agree to certain business decision once the investment has taken place. Number of reasons could be there. It could be the difference between opinion. It could be the difference between the understanding or the way they want to take it forward, the future of the organization. Always important to have a deadlock resolution clause, whether linked with a dispute resolution or otherwise. There needs to be clear understanding, or there should be some motivation for the parties to resolve the deadlock. And a number of ways are there how a deadlock can be resolved. Whether sometimes it even involves the sale of the shareholding of one or the other parties. So depending upon your future plans, long term, short term, mid term, and what the direction of the company you want to take in, a deadlock provision needs to be drafted very carefully. Termination, we already discussed. The consequences of termination is also one of the important clauses, because once the agreement is terminated, who gets what and how things move from there after the termination of the agreement. That's an important clause to look at. Exit, of course, is one of the most important clauses from the point of view of an investor in a company, especially if they're a financial investor, because their role is, or their main focus is, to invest in the company, get the valuation, and then exit, because that's their business. Now, number of exit clauses can be there. For example, IPO is one of the exit. There could be a sale to third party, or sale to the founders themselves. I believe my colleague Abhishek would be going more into details regarding the exit clauses. Non-compete is also these days finding its way into practically every agreement, where either the investors want to put a restriction on the founders from having a competing business, which is understandable, or sometimes even the founders of a startup, they want the investor not to invest in a competing entity. A good example of this would be investment by SoftBank into both Amazon as well as Flipkart. Now, or in Ola and Uber, right? Something, a well drafted non compete clause should be there, I believe, so that the investors' loyalties are not divided, because that would serve a startup in a long run. One more thing I wanted to point out in an agreement, any agreement, but more so in investment agreements, what we call conditional sentences and cross-referencing. Now, a notwithstanding clause. Lawyers would know a notwithstanding clause can basically change the understanding of 40 pages in one line. An agreement could run into 40, 45 pages, but one notwithstanding clause could alter the very course of that agreement, or could provide an exception to all the rules agreed. Similarly, a clause that start a wording that starts with subject to or without prejudice to. These are very important. These are like a dummy's guide for you to become alert to see the, okay, if this is there, I need to pay a little more attention to this. What is it really referring to? Does it create any exception to what we have been discussing so far? Uh, with the paucity of time, unfortunately, I wouldn't be able to define it or get into more details of that. But there's this slide would probably give you a better idea how it can change. It's a cartoon, I found um, online, where basically how a lawyer would wish happy holidays or Merry Christmas. End of the day, it ends up becoming, notwithstanding the aforesaid, entirely without prejudice, we would like to wish you all, to wish all our clients a very festive spiritual holiday season. It's a, well, lawyer's joke, so to say. A more tip, I mean, it shouldn't come as a surprise. We all know that if we don't understand or agree with anything in a document, we should not sign it. But to be very frank, I'm amazed at the number of signed agreements we come across where people do not understand or agree with certain things in it. So that is your clue when to consult a lawyer, because in the long run, it could really change the course of your, or your future could be decided based on whether or not you consulted somebody who could have advised you in a timely manner. That's it from my side so far. My colleague Abhishek will get into the details of this thing again, some of the clauses that we discussed earlier, and in the end of it, we'll have a question answer round. If you have any questions, please feel free to leave it in the comment section, in the chat box. Thank you very much.